community service. Is this how you understand the agreement?
I understand.
You also need to understand that DWI is big business. Because this is a second offense, you will be required to pay the DPS supervisor fee. So that is now $3,000 that you will be required to pay. And if you don't, then you will sit every day, 1 day in jail for every $100 you owe. Somehow I have to get your attention. And if it's not by money, then it will be through. Do you understand? It's unacceptable. Every single day, someone dies from a DWI in our county. No more. Do you understand? If you violate this probation, a warrant for your arrest will be issued. You will go to jail and I'm going to bring you back out. And you are looking at 180 days in jail. That means no drugs, no alcohol. You must do your classes on time. You pick up a new case, it's just not going to go well for you. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. How do you plead to this offense? Guilty or not guilty, sir?
Guilty.
I'm going to find you guilty. I will send you to this agreement. So how much is the total for everything?
Everything.
With the 3,000, please. Here's the other thing, Mr. Flores. Because you are taking an additional DWI education class, DPS may suspend your license. So before you start driving, you need to look and you need to contact DPS to see if your license is eligible. If it is not, you cannot drive. If you drive on a suspended license, you're in violation of this probation. Do you understand? Mackenzie, do you mind running his license now, please? So we can do the, divide it out by year.
Yes. His driver's license is not eligible, Your Honor.
You are not allowed to drive.
Yes,
You will be signing up an affidavit with me today promising me you're not going to drive. If I find that you drive, and I don't care what your excuse is, it's really not going to go well for you. Do you understand?
Understand.
Okay.
The court costs, including DPS fine, is $3,500.
What is that?
It's a handheld device.
35
That's including $15 payment plan fee.
Okay, so the total amount that you will be required to pay is $3,520. You will be able to pay it through while you're on probation because they will put you on a payment plan. I'm going to tell you, you get caught up again, it's a ton of prison time. You understand? All right, good luck, sir. Thank you, guys. Hi.
Back on Mercedes Spinks, you had indicated that you would lower her bond to $3,000. I've spoken with the family, they will pay that. I
Wow.
have the
Okay,
waiver and the other one, so I just think we just need a bond order, bill.
so Deputy Miranda, you mind bringing up Miss Spinks real quick? No. We're very lucky to have a family that's going to post this $3,000 for you. You need to understand there's serious, serious consequences if you fail to go back. You fail to go, I'm going to revoke this bond. I will set it at zero. The family's going to lose all that money. So do you want, all we're asking to do is go back to this jurisdiction within the 2 weeks of your release. Don't wait until the last day because it's Murphy's Law dictates what can happen will happen. And I don't care about excuses. So if you try to wait till 2 days before to go up there and my car breaks down, my dog died, but I don't care. Do you understand?
Yes.
So I would make arrangements as soon as you get out. Okay? All right.
I want you to know that she has a lawyer working right now to set up a court date, so hopefully she
I
can
don't
provide that.
care if you come back here and it's post 2 weeks and the lawyer hasn't done squat, it doesn't matter to me. Don't depend on whoever because it's on you if you don't make it up there within 2 weeks to turn yourself in. And they haven't done what they're supposed to do. They promise you the moon, sun. Okay, good luck.
Thank you, Your Honor.
Thank you, Your Honor. Have a great day.
You don't need another card, right?
No, I think I'm not right. If not, my daughter has mine.
Okay.
You want to do the?
Yeah, of course. Yeah.
Right there.
This is Mrs. Sparza.
This is Mrs. Esparza, or you may have her as Matthews.
Good morning, Mrs. Barzy. And you were charged with facing up to 6 months,
Keep it down, keep it down.
facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 30 days in jail with credit for the 60 that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this, it will go on your record. You can never change this. Is this what you want to do? How do you plead to the offense, ma'am? How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty, send you to the 30, credit for 60. You also need to understand that this now makes 2. What happens on the next one? Years instead of years. Oh, this was a long sentence. Then you're looking at years. You understand?
Yes, sir.
For a case of beer. Good luck. Okay, thanks, Lori.
Thank you, sir.
What's up, man? Been a long time.
Yeah,
Are you doing stuff upstairs more so?
well, they had an opening out in Fort Bend, so with my firm,
So you're more now out in Fort Bend?
yeah,
Okay.
I'm handling a couple of felony cases that were already set for trial, so I'm here today for a pretrial conference. So I had somebody cover my stuff out there. I'm covering her, stuff here. But yeah,
Are you here for who?
Miss Blackson, Bianca Blackson Newman.
I'm glad that you're here. We were waiting for someone. We didn't want to get started without you guys. So, all right. So your lawyer is here now. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Excuse me. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge.
Okay.
On February 27th, 2025, the officer was dispatched to the 3800 block of Mason Road in reference to a suspicious vehicle call. Call notes advised there was an unknown female who was asleep behind the wheel of her vehicle, which was running at the time in a moving lane of travel. Upon arrival, the officers made contact with the defendant and observed her asleep in the driver's seat of the vehicle, and the officers removed the keys from the vehicle to prevent further damage. As the officer was doing this, the defendant woke up and attempted to put the vehicle in drive and leave the scene. The defendant was unsuccessful, and the officers also observed an open container behind the driver's seat and observed an odor of marijuana coming from the vehicle. The defendant was detained and admitted to consuming alcohol prior to driving, stating she consumed alcohol 4 hours prior, then stating it was 2 hours. The defendant stated she was probably drinking tequila. The open container in the vehicle was a bottle of tequila, and the defendant was transported to the police station for standard field sobriety tests. HGN 3 out of 6, walk and turn 5 out of 8, one leg stand 1 out of 4. The DIC was read and the defendant consented to breath. The results were 0.118 and 0.115.
Are you telling me that she's drinking while driving or is
Your
there
Honor,
evidence of
behind the
that?
driver's seat is open. That would touch any indication that
Okay. Ms. Blackson, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Does she have any prior DWIs, number one? Number two, does she have a valid Texas driver license? Alex, please.
one moment, Your Honor. Her license is eligible and no priors.
Got it. Okay. Ma'am, so you can continue to drive, but you're not allowed to drive unless you have valid liability insurance as well. You must have car insurance to drive. Do you understand? Okay. Now you have a lawyer. Because you have a lawyer, I will waive your appearance. You do not have to waste your time coming to court, but you must stay in touch with counsel and they will tell you if and when you have to come back to court. If they tell me they can't get a hold of you because you've gone AWOL, you pick up a new case, you become a danger to our community, I will revoke your bond. You understand? Okay. I'll have you sign a reset with Victoria. We'll have you get with Felicia for your bond conditions, and after that, you're free to go. Okay? Thanks.
Thank you,
Great
Judge.
to see you, Robert.
Question on Mr. Weber. Let me hand this back to you.
State, did you see this? Okay. Can I,
Yeah.
okay, so, can I file that?
Counsel.
I have seen these filed in deeds before, so I would imagine. Confidential, confidential. There's a
Can you mark it confidential?
Yeah. I'll put it in seal. I'll put it in seal.
Okay, that's it. Seal it. Okay, because I don't, yeah,
Yeah, that probably shouldn't be
good
posted.
idea. Okay.
Judge, put you for PC on this one.
Well, hold on a second. I don't even have him.
Exactly, that's my problem. He's in custody and needlessly, without probable cause being heard. I was told that that was the reason I was appointed to him this
No,
morning.
no, no.
that
So
he
I appointed you because we had gotten those two letters. I didn't want to just file it and I wanted to take the appropriate action when we got, because we got those two letters. I don't know who sent it. All I know is that we got it and I wanted someone, that's why I appointed you to see it. I don't know anything about probable cause. I just know that we don't have him here today because I
Right.
guess he's still in processing.
Correct. So you will not entertain hearing probable cause without him. present.
I guess let's do it. Did the magistrate already hear probable cause? I mean, it looks like a magistrate already found probable cause. You don't think there's PC?
No, Judge.
Okay.
All right, March 4th, 2025, in Harris County, Texas. Officers were dispatched to an assault and call. Keep it down, keep it down. Officers met with the complaining witness, who stated that the defendant is her boyfriend of 3 years. Complaining witness stated that they got into an argument over where to eat. The complainant and defendant both denied that an assault had occurred. Officer then spoke with the witness, who stated that she observed the complainant in her vehicle. The defendant opened the front passenger door and punched the complainant 5 times with a closed fist. The witness stated that she then observed the complainant and the defendant get out of the vehicle, and the defendant punching the complainant several times with a closed fist.
Wait. Okay, so initially, the defendant allegedly punches 5 times, you said? Or the witness? Or
The witness observed the defendant punch
okay,
5 times. The witness stated that she then observed the complainant and the defendant get out of the vehicle, and the defendant punched the complainant several times with a closed fist. Officer then spoke with.
I mean, Abel,
Judge,
there's no PC?
the CW says that no assault or terroristic threat happened.
Okay, there were
Two
2
officers.
officers.
It's based on her feeling pain and she's saying nothing happened, Judge. If she's saying that she wasn't threatened, she wasn't threatened.
Well, no,
Whether 20 people or 100 people see it.
well, bodily injury can be inferred. You don't need somebody to say pain. You can infer bodily injury from conduct.
So what about the terroristic threat?
So the complainant at the end, the witness stated that the defendant stated to the complainant, quote, "I'm gonna fuck you up."
Again, if she doesn't take it as a threat, it's not a threat, Judge. We might think it is. And we can infer all we want, but that's not.
I'll refer that one to the court.
Say, okay, so it was at the time that the alleged assault is occurring? He says, I'm gonna fuck you up. And he allegedly follows through. I mean, I think there's enough for probable cause, it's such a low standard,
Well,
I don't agree. Let's agree to disagree.
Oh, sure, and we can, right? But we have someone who's punched her 8 times in the head. You're telling me that's not gonna,
Well, I mean, sometimes that behavior is not that it's defensible, but it is permitted under the law, whether it's self-defense.
that's-
I don't know, Judge. I don't know the whole
We
facts of the
can't-
case. I just have what the initial summary of the report is. So
I think that there's enough PC to
Yes, sir.
start to go forward.
I'd ask that you grant him, based on what the CW wants that the case be dismissed and what she's saying from the get-go, that you grant him PR bonds on these 2 cases.
I'm gonna be opposed, Judge. I don't think that the conduct here warrants any sort of PR bond. I think it's concerning that, there's a complainant who is adamant that nothing occurred, and the 3 independent witnesses are saying that she got assaulted, pretty consistent with each other.
So let me read this to you. So let me read this to you because there's more. It says motions for bond conditions, MOAP. Defendant assaulted and made a terroristic threat against a complaining witness, yada, yada, yada. Complaining witness denied same. However, there are numerous witnesses who heard the threats and saw the assault. Witness Kirby saw defendant swing at complaining witness 3 to 4 times and assault complaining witness. Witness Grantham saw defendant open passenger door to the car, punch complaining witness 5 times with a fist, Then complaining witness got out of the vehicle and defendant punched her 4 times in the stomach and in the shoulder. Complaining witness sit back, saw defendant punch complaining witness 5 to 6 times with fists in the vehicle, 3 to 4 times more when she got out. I think there's enough problems. And I'm not ready yet. He's in processing now. We'll get him, because the problem is if I grant a PR bond now, he's going to be out and I can't put conditions on. And I'd like to put conditions on, and, we can talk about it when we get him about a PR bond and stuff. Okay? The magistrate set bond on both of the cases. I'll keep it for now, and then we can talk about it tomorrow.
Yes, Judge. I also have Mr. Cortez,
Okay?
would request a PR bond. Don't shoot the messenger on this one.
I will never going to.
This moment is a masterclass in judicial reality checking. The judge lays out how a single DWI probation isn't just a class or two. It's thousands in DPS fees, mandatory treatment, possible license suspension, and potential jail time for every misstep. Many defendants think probation is the easy option, but here the judge makes clear it's anything but. Do you think this level of financial pressure helps deter future DWIs? Or does it just trap people in the system?
Begrudge you for, zealously advocating, really. Let me bring him out here. Let me talk to them. Do you mind bringing Cortez out real quick, please? Are you ready? Let me talk while they're bringing out. Let me talk. Okay. You are Joe Cortez?
Yes.
Mr. Cortez, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 4th, 2025, in Harris County, Texas, officer was dispatched to a disturbance call and made contact with the complainant witness, who stated that the complainant witness is her father. The complainant witness stated that her father had arrived and was attempting to load a shotgun as he was upset from a previous incident.
He was loading a shotgun?
Stated that a witness, her grandmother, and her were attempting to take the shotgun from him when the defendant hit the complainant on her left eye multiple times with a closed fist, causing pain. She stated that as he was holding the shotgun, the defendant stated to her that he was going to kill her, grappling his hands against her neck, applying minimal pressure as she was blocking his hands. The witness stated that the defendant had been upset due to a car accident and that today he was loading a shotgun. And when her and the complainant attempted to take it away, the defendant hit the complainant in the face multiple times. Officers observed the defendant as he was still holding a shotgun shell in his hands when officers arrived and observed a red mark on the complainant's left eye and forehead area.
So was it all housework?
He's currently unemployed and lives with CW, Judge. That's as far as I got with him in terms of anything going for him.
I got to tell you, your lawyer wants me to give you a PR bond, but Mr. Cortez, I got to tell you, you scare me, dude. You're on bond for a DWI third right now. You're allegedly loading a shotgun. You've got all this. You scare me. The last thing I want is more blood or a dead body, So don't say anything. I'm just telling you why I'm doing what I'm doing. Is my fear is that, something even more egregious happens if we give you a PR and you go back, there's nowhere else to go. And the last thing I want is a dead body. We have enough drama in this life as it is, I'm sorry, man. I can't. It scares me, I am ordering you now not to have any contact with complaining witnesses in this case and not to go within 500 feet of where they live or where they work. Do you understand? I don't know if you're going to bond out, but if you do, I'm putting a monitor on your ankle so I know that you're not anywhere near where these people live. Do you understand, Mr. Cortez?
All right.
Life is too short to live the next 30 to 40 years in a 6x9 box. It's not. It's way too short. Do you understand? All right. Thanks. Okay. Ms. Burns. No?
This docket showcased
I'm sorry,
just
man.
how
I can't.
overwhelming
It
the
scares
criminal
me.
system can be. Digital no-contact
I am
violations,
warning you now
violent
not to have
assault
any
witnessed
contact
by
with complaining
multiple
witnesses in
people,
this case and not to go
DWI
within
cases
500
with
feet of where they
extreme
live or where they
backs,
work.
and
Do you
probationers one
understand?
mistake away from
I don't
prison.
know if you're going to bond
Through
out,
every
but if you
hearing,
do, I'm putting a
one
monitor on
theme
your ankle, so I
echoed.
know that you're
The
not
judge is
anywhere near where these
prioritizing
people live.
community safety
Do you
above
understand, Mr.
all
Cortez?
else.
All right.
From weapon
Life
restrictions
is too
to
short
ankle
to
monitors
live the next
to
30 to
sky-high
40
bonds.
years
The
in a
court made the
6x9
consequences
box.
unmistakable.
It's not.
If you found this case
It's
as
way
shocking
too
as we
short.
did, make sure
You
to hit that
understand?
like button, drop your thoughts in the comments,
All
and
right.
subscribe for
Thanks.
more unbelievable
Okay.
courtroom
Ms.
breakdowns.
Burns.